Is it what you not even remove it again, just take it then.
Where the this one?
She likes melting.
Yes, this one. Ready?
Yeah, focus on
Alpha.
this one.
Yes, hello.
Which one you want? This is not
Sir, they started. All of them are muting. It's not online.
You finish adopting.
It's fine. Is it your God that called?
No, I'm not calling my phone. But I have seen it texting you message. I think
That's fine.
I think they are connected about the course. Okay. Yes, you can call the case. Sokoto, we are already here in Abuja. Sorry? Yes, one lawyer, but then we still have to.
Yes, my lord.
Yes.
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 The court registrar, are you there? Are they in the courtroom? Yes, but they are not responding.
Hello, good morning, my lord.
Okay, please go ahead and call the case.
Okay, my lord. Case number 1. NICN/SK/ between Dr. Umar Amir Rufai and the Wazir Umaru Perer Polytechnic and 2 others.
Yes, do you have any of the parties in courtroom there in Sokoto?
Yes, my lord.
Yes, my
the
lord.
claimant is
Where is he?
standing, my lord.
All right, okay, thank you. Okay, I can see him. Yes, defendants are absent. Any counsel? Yes, the Abuja counsel, are you for the claimant? Okay, yes, Munirat. Go ahead and announce your appearance, please.
Thank you, my lord. May it please the court. I'm Munirat. Oh, yeah, here. I appear for the claimant, my lord.
You can sit down. Thank you. Yes, defendant counsel, we are here in Abuja. Yes,
my lord. SM Mayaro.
SM Mayaro. Yes.
Here for the defendants.
Okay, we have SM Mayaro for defendants. So the matter is for judgment today. Yes, the judgment is. I will proceed to deliver same. So I will go ahead with the claims, introduce the case of the claim, defendant's case, submissions of counsel, and the issues raised. I will read the issues out, then now proceed with the decision. That's how we are going to go about it. Munirat, I hope Sokoto, you are still connected. We have to be sure that they are connected, so we don't just keep reading and they are not with us. Yes, Bashima, come over. Can you check if they are still connected?
Yes, my lord. They muted themselves.
Okay, Munirat, can you hear me, please?
My lord, we are connected, Sokoto.
Yes, how about the counsel there for the claimants?
Modera, we are not sure. She connected from her office, my lord.
All right, so I'll proceed.
Yeah, I think she's online, my lord.
She is, yes.
Yes, ma'am.
All right.
Yes, my lord, I can hear you.
She's okay. Thank you.
I can hear you.
Okay. I'll proceed with the judgment. Yes. This is an
Thank you, my
action
lord.
commenced at the instance of the claimant via the originating summons dated 22nd day of July 2021, filed on 23rd day of July 2021 against defendants hearing. However, after hearing the parties and pursuant to an order of court May 13th October 2022, the originating summons was converted to a complaint and parties directed to file pleadings. Claimant filed statement of fact dated and filed 10th November 2022 with other processes with 5 reliefs against defendants. 1, a declaration that the purported dismissal of claimant from the employment of first defendant dated 14 July 2021 is ultra-vires, illegal, unconstitutional, and void for want of fair hearing and compliance with laid down statutory procedure. 2, order setting aside the dismissal of claimant of 14th July 2021 for being null and void. 3, order reinstating claimant back to his office in the first defendant with all his rights and privileges attached and without loss of promotion with effect from the date of the purported dismissal. 4, order directing the defendant to pay claimant's accrued salaries from 14 July 2021 to the date of judgment in this case, and any other orders as court may deem fit to make in the circumstances. Upon service of the said processes, the defendants jointly filed their statement of defense and other accompanying documents dated 27 November 2022, filed 28 November 2022. Commencement date of trial was 30th November 2022. Claimant had his case opened, testified on his behalf as CW1, adopted his written statement of 10th November 2022. 25 documents were tendered, admitted in evidence, marked as Exhibit C1 to C25. And the claimant's case was closed 14 February 2023 after cross-examination. Defendants were foreclosed from defense upon application of claimant's counsel, having absented themselves from court without any reasonable excuse given. Matter then adjourned for adoption of final written addresses on the 4th day of May 2023. The claimant's address is dated 19th May 2023, filed 24th May 2023. Served on defendants who filed theirs on 4th July 2023, having regularized same by order of court. Claimant's counsel went on to file reply on points of law on 17 July 2023. Then 19 July 2023, the addresses were adopted in line with the rules of court and matter adjourned for judgment. A summary of the claimant's case. The claimant hearing asserted that he was employed by first defendant in the 1980s and that he was eventually dismissed from his service by letter of 14 July 2021. Facts leading to his dismissal are that he had written a complaint against a lecturer who was awarded a PhD for perceived plagiarism, which he believed angered the third defendant. Thereafter, that a complaint was made against him by an unknown person upon which he was invited by the Anti-Corruption and Transparency Unit of the first defendant to answer unknown allegations, and then he was suspended by the third defendant on 16 July 2020, contrary to his powers, when there was then no governing council for the first defendant. That the claimant was invited by letter of 28 June 2021, which is Exhibit C22, to appear before an ad hoc disciplinary committee of second defendant without being served with any allegation or evidence in incriminating him. Hence, he then informed the committee that he could not be tried by them because he had, in his opinion, all the members of the committee as appointees of the third defendant and that he had a pending action challenging his suspension. The claimant asserted that on 14 July 2021, the governing council of first defendant was inaugurated, had its inaugural sitting and decided on his case, which resulted to his dismissal on same date without hearing from him and contrary to section 17, 1 and 2 of the Federal Polytechnics Act. The claimant's final address. In the final address, 2 issues have been formulated. 1, whether having regard to the circumstances of this case, claimant was properly and lawfully dismissed from the employment of first defendant. 2, whether on the preponderance of evidence the claimant has proved his case to entitle him to this honorable cause discretion in his favor. Counsel has argued on the issue with authorities to support him. I'll proceed with summary of the defendant's case. On its part, to the defendant and arising from their pleadings, their case is that the claimant was a lecturer with the first defendant, was investigated by the Anti-Corruption and Transparency Unit of first defendant upon a complaint, then subsequently suspended by third defendant in the overall interest of the first defendant. The claimant was recalled from suspension and later invited to face an ad hoc disciplinary committee of the second defendant. That he appeared but refused to proceed with the hearing on the basis that he had filed an action in court challenging his suspension. That claimant was eventually dismissed after giving him an opportunity to be heard, which he failed to use. There are 3 issues for determination submitted by defendants as follows. 1, whether or not the claimant was afforded an opportunity to defend himself before the ad hoc disciplinary committee of the second defendant regards being heard to the facts of this case. 2, whether the dismissal of the claimant from the employment was in tandem with the extant laws. 3, whether or not from the content of exhibits, I think, is it exhibits? There's something, I think we are not sure. I have to insert that exhibit. Whether from the content of the exhibits being letter of dismissal, yes. Whether from the content of the letter of dismissal dated 14 July 2021, the claimant has proven his case to be entitled to the relief sought. Equally, the defendant's counsel has argued these issues. In the claimant's reply address, the counsel to the claimant contended that claimant's appearance before the ad hoc committee of the first defendant and writing a follow-up letter informing them that there was a pending matter challenging suspension was enough to halt their proceedings as the subject matter was then vested in the court. That defendant's counsel misconstrued the position of law in the cases of Salami and Dama and Ecobank, as the facts of those cases did not show pending matters in court. And flowing from the above, claimant's counsel submitted that the questions raised in defendant's counsel final address and the entire procedure used by defendants were without due regard to the guiding principles and laws. Counsel insisted that allegations upon which claimant was suspended were unknown to him, and that was the reason for his going to court, citing Judicial Service Commission of Cross River State and Young. Furthermore, assuming there was no pending matter, the said allegations against claimant were not within the powers of committee to decide, being criminal in nature, as he opined that only a court of law can deliver a verdict on it. He relied on the case of Akwa Ibom State House of Assembly and Obong. And equally, Obong Frank Okon. On the second issue of defendant's counsel to the claimant referred to the twin pillars of justice, audi alteram partem, and nemo judex in causa sua, that the defendants acted as accusers, investigators, and judges in their own cause against the claimant, thus they failed to comply with the procedures required in dismissing him. On the third issue, counsel argued that the contents of the dismissal letter cannot remedy the wrong committed by the defendant, and that claimant never raised any issue on content of dismissal letter, but the procedure used in reaching his dismissal, which he contends to be illegal. Counsel held the view that the claimant had proved his case on the preponderance of evidence and entitled to judgment. Now, decision of the court. The claimant in this case seeks the setting aside of his dismissal by the defendant as contained in a letter of 14 July 2021, which is Exhibit C25, on the ground that he was denied fair hearing in the process leading to his dismissal. Counsel, in addition, that is claimant's counsel to rely on other exhibits, relied on provisions of Section 17, Sub 1 and 2, Polytechnics Act to substantiate his claims. Defendants on their part have contended that they complied with all relevant provisions of the law, as well as conditions of service regulating the relationship of the parties, which was tendered as Exhibit C14 in dismissing the claimant, hence that his dismissal was lawful. I've taken time to peruse the processes filed by the parties. There are oral and documentary evidence, as well as the written submissions of learned counsel, from which this court now distills the sole issue for determination thus, whether the defendants complied with the relevant laws and its conditions of service in terminating the claimant's employment. A very fundamental and foundational principle of law as provided under Section 131, Evidence Act 2011 as amended, is that the burden of proof lies on the party whose claims will fail if no evidence is adduced. In civil disputes, this burden rests on the party against whose judgment will be given if no evidence is produced on either side. See Okeke and Okeke, 2019, 17 NWLR, Part 1701, 267 and 288, paragraph C. Thus, a party who seeks judgment before the court or determination of any right in his favor has the onus of proving by credible evidence his case or the facts in issue as held in APC and Elebeke, 2022, 10 NWLR, Part 1837, 1 at 35, paragraphs E to G. The law is tried that an employment relationship can be established either by oral or documentary evidence, and that where an employee alleges the wrongful termination of his employment, then the onus lies on him to place before the court the terms and conditions of the contract of employment and the manner those terms were breached. See UTC Nigerian PLC and Peters, 2022, 18 NWLR, Part 1862 at 297. Flowing from the facts and pieces of evidence before this court, it is apparent that the claimant's employment falls under the category of an employment with statutory flavor, which is above a mere master-servant relationship, where the master can hire and fire at will, with or without any reason. Also, the law is settled that set down rules and regulations must be followed in the termination or discipline of an employee, where he is adjudged to have misconducted himself in the discharge of his duties. Lunge and First Bank of Nigerian PLC, 2010, 6 NWLR, Part 1189, 1 at 57. The question begging for answer is whether the dismissal of the claimant was done in accordance with the terms of contract between the parties, which is what regulates their relationship and binding on them, for which the court will not look outside of it to determine their rights and liabilities. See Oforishe and Nigerian Gas Company Limited, 2018, 2 NWLR, Part 1602, 35 at 53, paragraph G. Now, the facts forming the crux of the claimant's grievance is that he was suspended by the defendants upon an unknown or undisclosed allegation, and that they proceeded to have a disciplinary panel hearing against him, even after he had informed them orally and by letter dated 2nd July 2021, they received 5th July 2021, which is Exhibit C23, that he had a matter pending in court challenging his suspension, thus that his subsequent dismissal from first defendant's employment amounted to deny him of the right of fair hearing. The principle of fair hearing is enshrined in Section 36 of the Constitution of the Federal Republic of Nigeria, 1999, as amended, in addition to several judicial pronouncements by our courts to the fact that a person who is alleged to have committed an offense or has an allegation against him shall be properly notified of the allegations against him, allowed to make a defense, tried timeously and by a competent body authority, among others. Also, where there has been a breach of the provisions of fundamental human rights, any action taken subsequent to such breach will amount to a nullity. See Uzokwa Lezonu, the second, 1991, 6 NWLR, Part 200 at 659. Equally, administrative bodies have also been enjoined by the courts to abide by such principles of natural justice. See Intewo and University of Calabar Teaching Hospital and another, 2013, Law Pavilion Electronic Law Report 2332, Court of Appeal. There is evidence before this court to show that contrary to the claimant's assertions, he was notified of the allegations against him by the defendants, as seen in his response to the allegations contained in Exhibit C21, dated 27th day of June 2020, where he wrote, I quote, "You may recall that on Wednesday, 24th June 2020, ACTU Woolford Poly invited me to answer questions on some allegations contained in 2 letters, one written by a student, Nuruddin Isiaku by name, and the other by an anonymous lecturer. The summary of the claimed allegations include the following: complaint on academic misconduct by some lecturers, including myself, 2, complaint on T/P supervision by a student, unquote. The above extract from the claimant's Exhibit C21 makes it apparent that he was not only notified of the allegations against him, but he knew, understood, and even gave detailed explanations in reaction to them. Hence, I am in agreement with the defendant's counsel submissions that claimant was duly notified of the allegations against him, whether orally or in writing. Else, where could he have gotten the heads of allegations contained in his response? Also, it was after he had appeared before ACTU of the first defendant that claimant was eventually placed on suspension by letter of 6 July 2020, annexed to Exhibit C24. I've had reason to peruse through the provisions of Section 17, Sub 1 and 2 of the Polytechnics Act, that's the Federal Polytechnics Act, as well as Chapter 8, Rule 4, A to C of Exhibit C14, which is a replica of the statutory provision aforementioned and states the disciplinary procedure to be followed in removal and suspension from office of senior staff . 7.25 of claimant's final written address. Claimant's counsel argues strenuously on the issue of fulfillment of what he referred to as conditions precedent before his dismissal. Where's the Bashima Commission? And we need to maximize this. Yeah, I can see. Okay, I think they are still connected. I'll repeat that again. At paragraph 7.16 to 7.25 of claimant's final written address, claimant's counsel argues strenuously on the issue of fulfillment of what he referred to as conditions precedent before his dismissal can be validated. It was his contention that the rector of the first defendant did not comply with the provisions of Section 17, Sub 2 of the Polytechnics Act and Chapter 8, Rule 17 of conditions of service of first defendant in suspending him. The defendants have on their part contended that the rector can suspend an employee where it will be prejudicial to the interests of the Polytechnic and then report such to the council. I have seen from the clear provisions of Chapter 8, Rule 5 of Exhibit C14 that the third defendant herein is saddled with such powers of suspension as was used in the suspension letter of the claimant, particularly paragraph 3, which is annexed to Exhibit C24. The claimant's counsel's contention that such suspension could not have been communicated to the second defendant at the time because it was not existent is baseless, as the power to suspend in that provision is not hinged on the communication to the second defendant. I find it necessary to state that the claimant in the instant suit did not claim any relief pertaining to the issue of his suspension, but rather all his reliefs revolve around his dismissal. Thus, I shall not expend precious judicial time on the legality or otherwise of the claimant's suspension. Going forward, the claimant, through his counsel, argued vehemently that because the ad hoc committee of the second defendant went on with his proceedings, despite having knowledge that he had instituted suit NIC and SKO 2020, thus that his dismissal is unlawful. Section 17(1)A of the Federal Polytechnics Act makes reference to giving notice to an employee of reasons to believe he has engaged in misconduct, which may result in his removal from office. A look at the exhibits before this court, particularly 22 exhibits, that is Exhibit C22, revealed that claimant was invited by the ad hoc disciplinary committee of the second defendant on specific allegations for a meeting on 6 July 2021, which he has not denied, and would by extension mean that there was already in existence at the time a governing council for the first defendant, which is the second defendant. The facts and evidence also reveal that claimant did not appear on the dates of the meeting, but refused to make any representation before them on the ground that he had a pending suit in addition to the letter written by his lawyer in that regard. See Exhibit C23, C24, and paragraph 21 of claimant's witness statement on oath. Furthermore, despite the claimant's contention of a pending suit, NIC and SKO 2020, it is my observation that no originating process or order of the court in that matter was presented before this court to serve as evidence of the facts above. For one, I do not see how the claimant intends to use oral evidence to prove contentious points arising from documentary evidence. See Section 132, Sub 1, Evidence Act 2011 as amended, and case of Sunguro and Yeku 2017, 9 NWLR Part 1570, 290 at 247 to 428. Sorry, at 427 to 428, paragraphs H to A. Secondly, and as submitted by defendant's counsel, there was no court order served on the defendants to preclude them from going on with the sitting of the ad hoc disciplinary committee. Thus, could they have breached the claimant's right of fair hearing by proceeding? I think not. In the case of University of Uyo and SL, 2006, All Federation Weekly Law Report, part 315, 80 at 100, paragraph C to E. The court held that it will not interfere with the internal administration of an institution or university. This is because it is untoward and unheard of for a court to make an order restraining an employer from taking disciplinary actions against his employee solely on the ground that he has filed a suit against the employer in court. And the only time the court will interfere is when an employee's right has been infringed upon. Hence, I find that claimant's refusal to proceed with his defense, if any, before the ad hoc disciplinary committee, even when he was physically present on the day in question, shows that he was given an opportunity to defend himself, but failed to utilize him, and so cannot cry foul by clamoring breach of fair hearing. See case of Ezechukwu and Nwoka, 2016, 5 NWLR part 1506, 529 at 554, paragraph A to D. In addition to the above, I must say that I find the argument of claimant's counsel lame to the fact that claimant's disciplinary process by second defendant was conducted in a day, particularly on 14 July 2021. This is because he failed to appreciate the fact that there is no how claimant will be privy to all the internal communications of the second defendant with its other committees, as it would seem that he had assumed that having its first inaugural sitting translated to when it was inaugurated. This, in my view, is at variance with even the contents of Exhibit C-22, which invited claimant for the ad hoc disciplinary committee sitting, which is dated 28 June 2021. I need to add also that contrary to claimant's counsel's submission that the third defendant's act of suspending him was not done in compliance with the conditions of service, particularly Chapter 8 through 5, because there was no governing council at the time. The law is trite that governance does not operate in vacuum. The fact that at the time of the claimant's suspension, the second defendant was not constituted does not impute that the daily administration operations of the first defendant, including disciplinary steps, will come to a standstill. More particularly as it pertained only to communicating such suspension to the second defendant and does not affect the power of the first defendant to so suspend the claimant, I so hold. Another point that needs to be resolved is the assertion by claimant's counsel in its reply addressed at paragraphs 13.0 and 14.0 that the allegations against him were criminal in nature. Hence, the ad hoc disciplinary committee of the second defendant does not have power to try him for such except a court of law. I should quickly point out that I have observed that the claimant never pleaded any facts relating to these assertions, nor led evidence in that regard. As such, claimant's counsel cannot lead arguments on them. Because the law is trite, the facts not pleaded go to no issue, and addresses, no matter how beautifully and brilliantly drafted, cannot take the place of evidence, and same is hereby discountenanced. See the case of Access Bank PLC and Case International Limited, 2018 LPLR 43668, Court of Appeal. Consequent upon the above, it is my finding that the subsequent consideration by the second defendant of the report made to it, which gave rise to the issuance of Exhibit C-25, that is claimant's dismissal letter, was done in compliance with the relevant requirements of the law and is thus lawful, I so hold. Flowing from the totality of all I have said above, it is my finding that the case of the claimant is baseless, lacking in merit, having failed to substantiate his claims by credible evidence, and is thus dismissed. Judgment is hereby entered.
We are grateful, Your Lordship.
Thank you, counsel. Thank you. Call the next case. Is the registrar there? Munirat, are you connected? Claimant's counsel, are you online, please? All right. We would like to
Yes.
proceed with the next. If the registrar is there, call the case from Sokoto. We do it here. Go ahead, Barnabas. So who is there? Call the case for me, please, to save time.
Case number 10. NHS at FK at 05 2021, Ibai month. And Vasily now.
Yes, I think they are connected. Yes, registrar, are you online? Do we have the claimant present there?
Yes, my lord, is in the courtroom.
Defendants absent. Yes, counsel, announce your appearance, please.
My lord, may you please because I'm Munirat Oyahia. I appear for the claimant.
Defendants counsel. I think it's a sister case. Yes, so I may just read the decision here. What is applicable in the first case is equally the same, but I may have to read the decision. So Munirat is a sister case. I will read just my decision. Munirat, are you still online? I see she keeps mute.
Yes, my lord.
Okay, it's a sister case, so I will proceed to my decision alone in this case.
Yes, my lord.
All right. So the claimant in this case is the setting aside of his dismissal as well by the defendants contained in his letter of 14th July 2021. This exhibit C12 on the ground that he was denied fair hearing in the process leading to his dismissal. In addition, relying on other exhibits as the provisions of section 17(1) and 2 Polytechnics are to substantiate his claims. Equally, defendants here contended that they complied with all relevant conditions of service and provisions of the law. The court equally has on the issues submitted by the parties, the court has arrived at a sole issue, which is whether defendants comply with relevant laws and conditions in terminating the claimant's employment. In the same authorities as in the sister case have been provided here as well. It's the case of Okeke and Okeke, APC and Elebeke, calling UTC and Peters. And the issue now is whether the dismissal of the claimant equally in this case was done in accordance with the terms of contract between the parties as what regulates the relationship. Their relationship and binding on them are equally cited here as in the sister case of Orisha and Nigerian Gas Company Limited. And on the principle of fair hearing, are equally cited here. In the case of Uzoku and Ezonu, same cases cited in the sister case, Ntewu and University of Calabar. Equally here, claimant's assertion, in its assertion, the court has stated there that there is evidence before it to show that contrary to the claimant's assertion, he was also notified of the allegations against him by defendants, as this can be seen in his response under cross-examination, which states thus: yes, it is correct that I was suspended by the Polytechnic. I was invited by the Anti-Corruption and Transparency Unit without knowing what the purpose of the calling is for. When I was invited, I was told verbally that there was a complaint against me. It was after that I was suspended. Also, paragraph 19B and C of his witness statement or note is stated thus: I appeared in the office and was still not served with any particular complaint from no one. That the ACTU unit told me that there was a complaint from an unknown person against him, but the complaint was not served on me till date. The above makes it apparent that was duly notified as well of the allegations against him, albeit orally or verbally. The same as in sister case, the court has cited the FETA and SPDC Nigeria Limited. Here at paragraph 7.16 to 7.25 of claimant's final address, counsel argued equally on the issue of fulfillment of what he referred to as a condition precedent before his dismissal can be validated, that is, before claimant's dismissal can be validated. It was the contention that the rector of the first defendant did not comply with the provisions of the Polytechnic Act and equally Chapter 8, Rule 17 of the conditions of service of the first defendant is suspending the claimant. And the defendants have contended this. And I have seen from the provisions of Chapter 8, Rule 5 of Exhibit C3, that third defendant is saddled with such powers of suspension as was used in the suspension letter of the claimant, particularly paragraph 3 of Exhibit C5 here. Claimant's counsel's contention. So the claimant's counsel's contention that such suspension could not have been communicated to second defender at the time because it was non-existent is baseless, as the power to suspend the provision is not hinged on communication to second defender. Everything here is as equally read in the sister case, so I will not bother going over it again. It will amount to repeating myself all over. I've equally cited the case of the University of Uyo and SL, the same thing as in the sister case, is a Chukwu and Owuka on issue of a fair hearing. All is the same as in the sister case. So I need to add also that same as the sister case, upon all this and the finding of the court is that the subsequent consideration by the second defendant, as in the sister case, of the report made to it, which gave rise to the issuance of Exhibit C12. C12 as a claimant's dismissal letter was done in compliance with the relevant requirements of the law and is thus lawful, I so hold. So flowing from the totality of all I have said above, it is my finding that the case of the claimant is equally baseless and lacking in merit, having failed to substantiate his claims by credible evidence, and is thus dismissed. Judgment is hereby entered. So it's the same as the sister case, so I don't need to repeat myself. I think that should be all for Sokoto. That's all for Sokoto. You're welcome,
Thank you, my lord.
Thank you, Munirat. That is all for Sokoto. So I think we can excuse you now. So we proceed with the Abuja matters. Thank you.
Thank you, my lord.
Right.
Yes.